Welcome to Driven by Justice, Missouri's consumer law show.
Hello and welcome back to Driven by Justice, Missouri's consumer law show with attorneys Bryan, Brody, and Alex Cornwell of Brody and Cornwell, LLC. Based in St. Louis and serving clients across Missouri, Bryan and Alex are trial-tested consumer protection lawyers who fight for everyday people wronged by dishonest dealers, lenders, and debt collectors. I'm Kevin Rosenquist, and today we're unpacking the Missouri Lemon Law. Bryan and Alex will explain what kinds of vehicle problems actually qualify, how the process works, and when it makes sense for you to call a lawyer. Bryan, Alex, great to have you back.
Thanks, Kevin. It's good to be back.
Bryan, you've handled hundreds of lemon law cases across Missouri. For listeners who may only know the term from car commercials, what exactly does the lemon law cover?
There are two main lemon laws. There's our Missouri state lemon law, and that covers new motor vehicles. There's also something called the Magnuson-Moss Warranty Act, and it functions like a federal lemon law, and it covers any product, not just cars, that comes with a warranty. Both of them are designed to cover personal, family, household type products, meaning not primarily used for a business. And both of them ask the same question. Has there been an unreasonable number or length of repairs under a warranty? Or perhaps have they been unable or unwilling to actually fix the product under the warranty or the contract? The state lemon law, our Missouri lemon law, allows a consumer to seek a repurchase, a buyback of that vehicle from the manufacturer, not from the dealer, where the Mag-Moss, the federal lemon law, is more about the amount of money the consumer should get because the thing they got wasn't maybe worth what they actually paid for it.
Okay. So is Missouri's version unique compared to other states?
All 50 states have a lemon law that covers vehicles. What's unique about ours, well, there's a couple of things. The first one is that we have a very short statute of limitations. So that's the length of time that you get at a maximum to file your lemon law claim in court or forever lose your right to do so. Ours is only 18 months from that day of purchase. So it's really important that if you think you have a lemon, you have to act sooner than later. Another one is that we have what's called a presumption that a vehicle becomes a lemon if it's had 4 or more repairs for the same thing, or if it's been out of service by reason of a warranty repair for 30 or more working days. And a presumption means that when you hit that 4th repair or that 30th day, you're still waiting for your car to come back, that you are automatically considered to be owning a lemon vehicle. And the rest, while not easy, is a lot more straightforward than some of the other lemon laws. The third thing has to do with the calculation for how you do that buyback, because as they say, devil's in the details. And so of the 50 states, 48 require some kind of offset, a deduction from what they might otherwise owe you when they buy that vehicle back. Of those 48, 47 give some kind of clue, a hint as to how to calculate that amount. And then there's Missouri. So we don't even mention the word mileage in terms of, well, they're not going to give you all the money that they think they should give you back because you've had a reasonable allowance for usage, but it doesn't say mileage. There's no one-size-fits-all formula. The thing that we like to say is that means that every single case is a negotiation over what that deduction, if anything, should be.
And to follow up on that, Kevin, because it's important, because Missouri is a little bit more open and the definition is a little more nebulous. It's in the abstract. What we've encountered when I say we, Bryan and I, is that even in the rare instances where a manufacturer has agreed to a buyback without having to call an attorney or to take the litigation step, in those rare instances, we invariably still often get involved because of that, that negotiation with the consumer. They know that Missouri doesn't have those defined parameters. And so not to say they take advantage, but just as a practical matter, we find that the offers they're getting, the calculation for the repurchase, because it sounds like, a repurchase, I'll just drop off the vehicle and you'll give all my money back.
Right.
That is not what happens in practice. And so it helps to have some folks who deal with this on a daily basis to navigate those channels. So even in the instances where an agreement to reimburse or repurchase a vehicle is in place in principle, I would still nevertheless urge someone to give us a call to make sure that they're getting the correct numbers based on our experience. And
Bryan, how many days did you say you have to file?
So Missouri requires 30 or more working days. And they don't define, meaning our legislatures in their wisdom, did not say what working days means. So one of the disputes that comes up is, what about Saturdays? Most shops are open on Saturdays. That feels like a working day. Most manufacturers, when you're saying, hey, I'm entitled to a buyback, it's been 30 days, might say, well, what you really mean is it's 26 or 27 days. So not quite at a number where we're going to buy it back, because they're only going to count Monday to Fridays. And so it's sometimes an argument that we have to make. But it's another reason why sometimes we tell consumers, maybe if you're getting close to that 30-day mark, don't be the squeaky wheel for a couple of more days so that there's no dispute that let's not include the day you dropped it off. Let's not include the day that you went to pick it up. Let's not include any Saturdays, even though I think those are absolutely working days. And let's certainly not include any holidays, because those might not be working days. That's when you get to that 30-day period, that's when we can convince a manufacturer, hey, it's time to just take this one back. Not another repair and another repair and a promise of another repair.
Right.
It's time to pay the consumer.
Absolutely. Alex, when a client calls about a new or used car that keeps breaking down, what's the first thing you look for to decide whether the law applies or not?
Well, in the very first thing we have to answer, obviously, is what you just said. Is it a new or used vehicle? Because that will tell us what law we're going to apply. And what law we're going to apply, as Bryan mentioned, dictates what remedy, what outcome we can conceivably get. Because a lot of folks will call and use lemon law in a colloquial sense, meaning anytime I buy something that's wrong with a car, is it a case? And the answer, unfortunately, is no. If it's a used vehicle, we don't have that nice defined 30-day parameter that Bryan had just mentioned. So it is the definition for the used vehicles, the standard is whether or not it was an unreasonable number of repair attempts. To answer that question, then, what we need is the repair documents, the repair orders. All dealerships have an obligation to provide those to you. Now, oftentimes they'll just keep them, and not give them to you unless you ask for them. But if their question for a potential client is, all right, does my vehicle meet the definition of a lemon, whether it's under Missouri's lemon law or the federal used car lemon law, we have to be able to see, make that calculation and look at the repair orders. And a lot of times, since it's not as defined as Missouri state lemon law, when we're looking at a used vehicle, to answer the question of reasonableness, it's both a qualitative and a quantitative judgment. What I mean by that is, sure, if your vehicle was out of commission, out of service for 60 days, that to me, 2 months, that's unreasonable.
Yeah.
If the issue was a windshield wiper or your radio, well, closer call. If the issue was an engine or a transmission, that's where that qualitative judgment comes in. Where, if I have to disclose that my vehicle underwent a 2-month engine repair, even if it's fixed, it might affect its use down the road. I might have a lesser trade-in allowance. So the types of issues are also a relevant factor in us determining whether we think it is unreasonable based on its repair history.
Bryan, what are some of the most common ways that dealers or manufacturers might try to avoid responsibility once a customer starts complaining?
So manufacturers in general are well aware of the lemon laws.
Sure.
They know that their job is to repair the vehicle. But one thing that we see a lot is they'll start with the cheapest possible and the fastest possible repair. And then they assume that it's your job to bring it back in. So part of what might make something unreasonable is, why did you try this, that, and the other thing before you actually fixed the vehicle? So, for example, why give us a new engine when we could try these other smaller parts that's faster and cheaper? And in practice, I understand why that might make sense for manufacturer, but it definitely shifts the problem to being on the consumer to just continue to put up with the problems that they're dealing with. Sometimes they don't agree that there's even warranty coverage. And this comes up less, I would say, with manufacturers, but often with what we call extended warranties. Now, the law calls them service contracts, but colloquially, we all refer to them as extended warranties. And for these, they're separate third-party companies. They're not the manufacturer of the vehicle. They're not General Motors. They're not Ford. They're not Toyota. They are a separate company that says, hey, we'll provide some coverage right once those original warranties have expired. And these companies will try to find any way possible to deny coverage. Sometimes you say, I've got a radio problem. Well, tell you what, before we agree to that, we want to see the last 3 years of your oil changes. What's the connection? None at all. They're just looking for some basis to try and deny that they have to have coverage here because it's expensive. And look, I get it. Companies don't make money by giving it away, but there needs to be some connection between what they're looking at and what the problem actually is before they go about denying it. And we often see in this context what we call pretextual reasons, right? That they're going to say, well, this part broke and that caused this other part to break. But since we don't have coverage for the original part, we're not going to cover it. And oftentimes this requires not just good lawyering, but a good expert mechanic to inspect it and give us the information as to here's why that doesn't make sense mechanically. And because we do this so often, we know expert mechanics, expert witnesses who are ready, willing, and able to inspect the vehicle and come testify as necessary to try and shut these kind of pretextual reasons down.
Mm-hmm. In terms of the manufacturers, though, what a common type of claim that we do encounter, when I say manufacturer, that you envision Ford, they produce the vehicle. So we have someone call with a Ford F-150. Said, I had the engine worked on at 75,000 miles and my warranty goes out at 80. And Ford does a 75,000 engine repair, turns around, 85,000 miles we're now on it. So we're past that deadline, that warranty expiration limit, and the vehicle still hasn't been fixed. The engine issue is still popping up. What Bryan and I take the position of is you didn't fix it within the warranty, even though you had the opportunity to. So that's still an ongoing repair attempt. Even though you can't wait out the clock, even though now it's 85,000 and you allegedly our warranty expired, we got in before the expiration. So that type of claim we do unfortunately see, and it's one in which we're pretty bullish about, that you can't rely on your own inability to repair it when you had the opportunity to now defensively say, oh, sorry, you're out of time.
We say it's not like the shot clock in basketball where, phew, we did it. We made it past the time period and now we don't have to worry about it again. If you've reported it at least once, if you've had at least one repair during the warranty period, the obligation remains. Make it right. That's the whole point of a warranty, right? Is a promise that not that you'll get a perfect vehicle. That's not what we promise anymore. What we promise is that if a problem comes up, we will fix it. And fix it has got to mean more than good old college try. It means we're going to solve the problem so you could use the vehicle as you intended. And so it kind of speaks a little bit to the question of what makes something reasonable or not in terms of the repair history, where take a normal person off the street and ask them, show them the repair history. Does that seem like a reason you would be okay with that? We take 12 of those people, put them in a box, we call them a jury. That's the whole concept behind all of these lemon laws is if you heard that story, just a random person off the street, would you find that you would want to be put in that same position? And if not, it's probably a case.
Mm-hmm. Mm-hmm. Alex, what records or evidence tend to make the biggest difference when trying to prove a lemon law claim?
Lemon law claims in that sense, Kevin, are a lot easier than all our other types of cases because it really is proven or disproven based on the repair orders. The one thing further I'll say about that is sometimes repair orders are not written for the consumer. They're written for the technician, the mechanic. So there might be certain things that are listed within that repair order that almost are like you're speaking French. So because of that, what we usually will do is after we compile those repair orders, we'll send them on to an expert at our own cost to review those records and kind of tell us, all right, what is actually going on here, as opposed to, what the mechanic told our potential client. Because of that, we can then dictate, all right, is this a case yet? But it all stems from the repair orders. So to answer your question, absolutely imperative to get the repair orders. And what we've also encountered is it's a lot easier for consumers to informally get their repair orders than having someone in a suit and necktie calling a dealership saying, hey, I'd like to see those repair orders for, John Smith. because immediately that dealership will claim up. No offense to them, I probably wouldn't want a lawyer calling me either. So because of that, it's it's a lot easier to catch more flies with honey than vinegar. It's a lot easier to get a friendly voice calling saying, "Hey, I had some work done at your shop. Can you please provide me the repair orders?" As opposed to, "Hi, I'm an attorney with Brody Cornwell. I need you to send me these repair orders. I'll subpoena you." No one wants to feel that kind of conversation.
Right. Yeah.
What I would say is, if you do think there's a potential for you having a lemon law case, having an issue with your vehicle, make sure you got all your documents in order, because that will make our job a lot easier in ascertaining whether it's something we can assist with.
Sometimes we do have customers who have gone to a shop but didn't get the document. And sometimes they don't even create one. And the best advice that we can add is, look, in an age of smartphones, take a picture, geotag yourself with the date, the time, the location, maybe grab a card if you don't have that, right on the back, date and time. And that's the person that you talk to. It's still a type of evidence. Are the repair orders better evidence? Yes, they are. It certainly would make your case easier if we have the document showing you were in and a warranty repair was done. But if they won't give you one, if you think that they gave you a quick checkout and said, we think it's fine, it counts. The precedent in our courts say that just because they didn't do a repair, they didn't fix a part, doesn't mean that it doesn't count. But you got to keep track of it. Don't assume that they will do it for you, whoever they may be. Keep track. Just record date, time, location, pictures, like I said, business cards, anything to remind you later, a month, 2, 6 later, this is what happened on this date.
Mm-hmm. So does lemon law only apply to new cars, Bryan?
The Missouri state lemon law only applies to new motor vehicles. And that's the gold standard. That's the one that, all things being equal, is the better remedy. Give the vehicle back to the manufacturer so you never have to worry about it again. Get out from underneath that lemon law problem. And that only applies to new motor vehicles, meaning you are the first owner. Doesn't mean that perhaps they could have been used as a loaner car, but ultimately you are the first titled owner of that vehicle here in Missouri. But the federal lemon law applies, again, to any product, but including used vehicles, assuming there's a warranty. We do get calls sometimes that say, "Hey, I've had 3 repairs for the same problem." But if it wasn't covered under a warranty or an extended warranty in the first place, that's not a lemon claim. Now, there may be some other claims there. What are they doing? Why is it still not fixed? Are they just wasting your money and time? But that's not a lemon law. A lemon law is where someone else is paying for that repair, and you have to keep going in again and again and again, or they keep coming out to you again and again and again. And as long as it comes with a warranty, a promise, a written contract, service contract, there's a lot of different names for them, then we can make a federal lemon law claim. And that's where we call it cash and keep. But the idea is it doesn't change the warranty, doesn't change the title, it doesn't go on Carfax. I really tell people, think of it more as an after-the-fact rebate. Oops, the one you bought wasn't worth the price you agreed to pay for it because of this unreasonable repair history. That difference between what you paid and what a reasonable person would have paid, if they had but known at the time of purchase what we all know now, that difference, that's how much your case is probably worth. Plus, they have to pay our attorney's fees on top of and in addition to that.
And Alex, is that the attorney fee recovery in that we've talked about? I think we talked a little bit about it in the last episode.
It is. And it's, every single type of claim that Bryan and I handle has a fee shifting provision. And as we've discussed previously, that fee shifting provision means if we settle a case or if we have to go to trial and win a case, the other side, the wrongdoer, and here, the warrantor, we'll say the manufacturer or a service contract, would have to pay our client's attorney's fees. And sometimes we get a question is, all right, what if we lose? In that case, we tear our fee bill up. We don't get paid at all in that case. We're out all the time and all the costs that we've expended. And that's why it's important for Bryan and I have to have we put a lot of effort up front to make sure a case is worth pursuing, not just for our clients, but for ourselves, because we're not helping anyone by just going through the motions. We want to make sure we file good cases and strong cases. And that's why a lot of the issues that we've talked about in terms of getting the evidence, getting the paperwork, having a good, upfront conversation with either myself or Bryan is so very important, because by the time we file a case, we want to know that we're already going to win.
That's the risk we're willing to take to get to handle these cases. Some manufacturers won't offer anything. But even the ones that do tend to offer low, unfair settlement amounts, as Alex has alluded to before. And I've joked that these places could probably put us out of business if they would just handle these in a fair and friendly manner. And we are more than hundreds of cases, more than 1,000 cases down the road, in no danger, apparently, of them ever figuring this out. It's important to remember, these are multinational, multi-billion-dollar corporations. You need to level the playing field against them. That's where we step in.
Mm-hmm. I like that. All right, well, that's it for today's episode of Driven by Justice, Missouri's Consumer Law Show. If you'd like to learn more about attorneys Bryan Brody and Alex Cornwell and their work, visit brodyandcornwell.com. They represent clients across Missouri in auto fraud, lemon law, and debt collection cases. Thanks for listening. Don't forget to subscribe to our channel. We really do appreciate it. Bryan and Alex, I really appreciate your time. Thanks so much.
Thank you.
Thanks, everyone.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.